Okay. Good morning, ladies and gentlemen of the press. This morning, the Supreme Court gave a ruling in respect of our motion to reopen the petitioner's case. You will recall that motion was filed a few days ago with a view to having the opportunity to reopen our case and have the chairperson of the Electoral Commission, Mrs. Jane Adukwe-Mensah, testify. And in our case, we wanted her to come in and testify as an adverse witness. Now, that is allowed under the rules, specifically Section 72 of the Evidence Act, allows a party whose interest is adverse to another party to call that party and treat that party as a hostile witness. Now, the strategy that we had adopted was basically to serve a subpoena on her, because as you recall, she had decided that she was not going to give testimony even after filing a witness statement. And we decided that we were going to call her by compelling her through a subpoena that would have been issued through the court system and served on her. But today, the Supreme Court gave a decision in which it basically said that Mrs. Jane Adukwe-Mensah will not be compelled, to testify. In our view, the court was wrong. In our view, the reasons of the court were based upon wrong legal premises. But the Supreme Court is the final decision maker when it comes to the law, and we have no reason not. We are bound by what it has said. This morning, we cannot depart. From it. But lead counsel for the petitioner has indicated that he is filing an application for review with respect to the earlier decision rendered on the 11th of February, relating to their decision with respect to the compellability of the witness testimony of the Electoral Commission. Now, ladies and gentlemen of the press, the Supreme Court asked itself a question which we deem was a wrong question and answered that question. It said, why does the chairperson need to account to the people of Ghana when she's not a party to the suit? Now, you will recall that counsel made it very clear that one of the reasons why we are in court is because of the unconstitutional conduct of Mrs. Jane Adukwe-Mensah as the returning officer under the Constitution. And it is not true that there is only one issue that needs to be determined in this matter. I am surprised that the Supreme Court itself, having set down 5 key issues to be determined, is now reducing the issues to one, which is whether and the extent to which the evidence that we have led shows that no one got more than 50% of the votes in accordance with Article 63 of the Constitution. But we had made abundantly clear in the petition that there were a number of infractions. We are contesting even the constitutionality of the declaration that was made. We are saying that she violated Article 23 of the Constitution because she is an administrative body. We have also said her exercise of discretion was contrary to Article 296 of the Constitution. These are all germane issues under the Constitution and laws of Ghana. And to reduce the petition into a single issue petition is rather unfortunate and smacks of a predetermined agenda to rule against the petitioner in this matter. The Supreme Court was called upon this morning to exercise discretionary power judicial discretionary power with respect to whether we should reopen our case. Now, in doing so, the court was bound by the provisions of Article 296 of the Constitution, and we think that the reasons, as I've said, that the court gave are not acceptable. They are not tenable. The reason is simply because you cannot expect that we should have made our evidence the evidence that we're going to present to the court available ex ante or before the fact, so that the court will now determine whether or not this is evidence that will help the case. In any case, the petition and other pleadings filed before the court makes it clear, and any trained lawyer will know that the pleadings show very clearly the evidence that would be led in order to be able, to prove the facts in issue. And so for the court to say that we were bound by law to make our evidence available for it to assess before allowing us to reopen our case is a legally problematic proposition. And therefore we disagree with the court. We think that the court, by this decision, has not done the people of this country a great service, in the sense that Ghanaians are interested in knowing the truth. Our constitution is very clear that justice emanates from the people and must be exercised in the name of and for the welfare of the people. The justices today have not given us a reason to believe that they want the people of this country to know the truth about what happened, that they want the people of this country to be able to say why figures kept changing on the from the 9th of December till date. If you go to the website of the Electoral Commission, the figures have changed 5 times. Are we not worried as a nation that the returning officer appointed under the Constitution cannot even explain to us what happened? She made a declaration based upon a figure that she herself changed without recourse to the law. Is this something that we want public officers to be, engaging in? And secondly, she's a public officer. And as a public officer, she's accountable to the public. She's paid with taxpayers' money. Why is it that she cannot be called to testify? Why is she being treated as if she's a private person? Why is she being treated as, why does the court treat this important constitutional matter under Article 64 of the Constitution, something that could have been brought by an ordinary citizen of this country, as if it is a mere private matter, as if we are involved, as I said a few days ago, with a debt collection matter? This is not a debt collection matter. This is not a commercial litigation that we are engaging. And so we are highly disappointed with the decision of the court. Maybe the issues that we have raised today will feature in the review application that we have brought before the court.
The motion for stay. And
we are also filing a motion for stay of proceedings pending the hearing of our review application. So thank you very much. If you have any questions.
Doc, at the risk of social media abuse, I have to ask, how much further, how much longer is your side going to go? For a number of applications now dismissed, the substance of the case itself, we haven't had a pronouncement on that yet, and so we cannot seek to say what would come out of it. But at these very press conferences, sometimes the comments that we get from your side suggest that you don't even believe in the ability of the court to determine or give an impartial judgment. I would reference a comment you just made that suggested that the ruling we had today was predetermined. How much further are you going to go?
Well, thank you very much. We are determined to go as far as the law allows us to go. And that is because we want the people of this country, the discerning citizens of this country, to see everything play out in the court, and that is the highest court of the land, and for us to be able to let everyone see that our resolve to pursue the truth is unrelenting. So we'll go to all the lengths allowed by law. As we have said, the Supreme Court has a review jurisdiction, and we are invoking that jurisdiction to take a second look at its own decision. And the review application will be filed with very solid legal arguments that we think should convince the court. If the court is not convinced, whatever options are left, we will pursue them. But we are doing this for the people of this country. His Excellency John Dramani Mahama brought this petition for the defense of the Constitution. He has a community of interest with the Constitution. And I want to make one thing abundantly clear. Sixtus, if you were the plaintiff in this matter, if you had sat in the comfort of your room and tallied all the figures, and if you were convinced that this matter, the declaration was in error, the Constitution allows you to bring an action. And your community of interest is with the Constitution, to defend the Constitution of this country. The judges have sworn an oath to defend the Constitution of this country. And so every constitutional issue that we think is germane and legitimate towards the resolution of this matter, we will raise until final judgment is given.
Thank you very much. I stand corrected that the very heart of this petition is the fact that the petitioner claims that no candidate attained 50% plus of the total votes.
Valid votes, thank you. And the petitioner has come to court again, also asking the court to annul the results as were declared on the 9th.
Okay, yes, on the declaration.
On the declaration, yes. Okay. Now, my question is, so far, has the petitioner been able to prove that none of the candidates actually got more than 50%? If no, is it going to be through the cross-examination of the first respondent that will reveal that none of them had more than 50%? If no, then your case is dead now, is it?
Well, don't prejudge the case at the risk of being held for contempt. I would dare say that the case we have brought is very clear on the face of the petition. If you read the petition, it is very clear why we have brought this matter. Now, in respect of the figures, we made it abundantly clear from the beginning that these were figures compiled by and announced by the Electoral Commission. You remember that we wanted to inspect documents. Our request was not granted. You remember that we wanted her to answer interrogatories, which are allowed under Order 22 of the High Court Civil Procedure Rules. At first they said they were not applying CI 47, and subsequently they had to rely on CI 47 to save themselves. All right. So, they did not permit us to administer the interrogatories. These are all mechanisms allowed by law to elicit evidence. And I don't see why the petitioner in this case, or anybody filing a petition as a citizen of Ghana in this case, cannot obtain information from the person who conducted the election for purposes of proving that the declaration she made was unconstitutional because none of the candidates obtained more than 50% of the votes. And let me say this, you see, there is a tendency, and I think that is where we have all gotten it wrong. Okay? I gave the example of Sixtus, you know, as an ordinary citizen mounting this challenge. Could the court have asked Sixtus to go to all the 275 constituencies and bring pink sheets? But read Article 64, Clause 1 of the Constitution. It says any citizen of Ghana may bring an action. So you can rely on the evidence compiled by and announced by the chairperson. In fact, in any jurisdiction, having seen situations of multiple summary sheets coming from regions, having seen situations of pardon, vote pardon, and admission of vote pardon by the respondents themselves,
It's enough.
the court itself would have ordered an inquiry into the extent of vote pardon. And that would have not been based on our figures, it would have been based on the figures compiled by the Electoral Commission. And by the way, no party that goes into an election produces figures. The official figures are produced and announced by the Electoral Commission of the Republic of Ghana. Why is the commission not throwing that evidence to all of us to say, look, here it is, this is what we did, now tell us why we were wrong? Why are they not doing that? And why is it that you as journalists are not asking that question of the Electoral Commission? You know, the notion that just because the principle of law is that, you know, he who alleges must prove, then it means that because the petitioner has come to court, he must produce the evidence by himself. Cross-examination is one way by which you can prove that burden. Why are they running away from cross-examination? Why are they running away from bringing evidence? And by the way, we filed a notice to admit facts. Okay? The law is that after 14 days, if you don't answer, if you don't admit, those facts are deemed in law to have been admitted. All right? So, in fairness to the petitioner, the facts enumerated, you know, for admission are deemed admitted. And let me say this. You see, they have decided they are not giving testimony. What is the legal consequence of that? It means that our petition and the evidence laid in proof of the petition stand unrebutted. That is the position of the law. And let anyone come and challenge me that that is not the position of the law. The court should have actually gone ahead to strike out their figures, their witness statements and their pleadings. Why is the court not doing that? That is a legitimate question that the petitioner is entitled to ask. That is not the position of the law. The court should have actually gone ahead to strike.
To be cross-examined, testify and be cross-examined. The court in today's ruling said that you had not proved the relevance of testimony. Doc, you are shaking your head. Indulge me when maybe. You had not proved the relevance of her testimony to your case. It's one of the many things that was said in the ruling. I don't have the benefit of a written text. I just had to listen to it.
Yes.
And you have demonstrated again at a lot of these encounters that there's a critical part of this case that is hinged on Madame Jean Mensah's testimony and her cross-examination. And it seemed that is where we are now.
A lighter note. But Sixtus, I think you may be going down the route of saying that, look, we haven't produced sufficient evidence to be able to discharge our burden. We think we have. All right? And again, the legal consequence of not testifying will have to kick in. All right? At this point in time. And I think that it is important that we highlight the fact that they have decided they are running away from giving evidence. And as journalists, I think you should be asking them more critical, questions than you are asking the petitioner. At the risk of being, petty, I think you are being unfair to the petitioner. You journalists are being unfair to the petitioner. You are not asking them critical questions. You file a witness statement. You represent it to the entire world that you are coming to give evidence. Why run away? And by the way, before you come in, let me say this. Before you come in, you have you saw the video in which Mr. McMenu said that they could also prove that there was pardon in favor of John Mahama, right? Is the court not interested in that? McMahon basically admitted that there was wrongdoing by the Electoral Commission, but the wrongdoing affected both parties. Is the court not interested in that? So that Jean Mensah could come and then say why she parted votes in favor of the petitioner and parted some in favor of the respondent. And then also let us see the extent to which the vote parting helped one party or the other. Isn't that an important question that needs to be answered? And who best to answer the question than the person who declared the results?
You made a point about the fact that as it stands, your evidence has not been rebutted. Should that not be good news for you and allow for the case to proceed for a judgment to be delivered? Then the second point, Doc, at the start of proceedings, we cited a letter that had been written asking for some additional arguments to be made. The court said it has noted that. Do you think that if you had the opportunity to perhaps address the court on that, it could have changed how things went? Then I realized that...
Yes. Well, if we were interested in just legal technicalities, like, you know, the court, you know, is applying legal technicalities at this point in time. We are not interested in just the legal technicalities. We are also in pursuit of the truth. That is why we think it is important that she should testify. All right. In addition to what we have, I mean, the evidence we've led, we think that if she testifies, Ghanaians will see that we didn't just come to this court making vain allegations without proof. We have led evidence, sufficient evidence to show that there was vote parting, sufficient evidence to show that there were, I mean, conflicting figures from, I mean, regions and constituencies and so on and so forth. All right. So we also made, I mean, it also came out very clearly that the Form 13 that she said was a Form 13 wasn't a Form 13. Okay, and as I promised you yesterday that there will be very, you know, salacious evidence coming out with respect to Form 13. And I told you that Form 13 is the reason why they are running away.
And is this evidence that was not available before you now?
Form 13 was available to us. All right, but Form 13 wasn't put in our, I mean, we didn't put Form 13 in. Form 13 was put in the witness statement of the electoral, of the first respondent. Now, Akable, you do remember that there was an attempt to put that form into the evidence through Dr. Michael Pesa-White, and we resisted it. And then it was Justice Gertrude Tokuno who still pressed, and the form was shown to Pesa-White. And you heard what Pesa-White said. When he said it, the court went very quiet.
Repeat what he said.
All right. He said, this is not the Form 13. That the Form 13 as spelled out in CI 127 is different from this one. Was counsel, my good friend Mr. Justin Amenuvo, not in court? Why didn't he protest? And why didn't he, get up to show to the court that the Form 13 they had presented was the same as the Form 13 in 127?
Finally, I was asking about the letter and the court.
Yes, the court, we thought that, you know, if we cited those authorities, it will assist the court, okay, because it's a court of law and a court of justice. And therefore, the issue, you remember that the issue was raised very late at the proceedings yesterday, when Justice Mafusau basically said that there was a judicial bar, you know, because Jean Mensah was not, she was a party to the proceedings. And we said, no, she's distinguishable from the Electoral Commission. All right. There was no time for us to be able to address the court sufficiently on the matter. But upon further research, you know, we decided that we're going to cite these authorities to the court to assist the court in coming to a tenable legal conclusion. Unfortunately, the court took the letter, but decided to treat it with contempt.
Is it your contention that if the Supreme Court goes ahead, based on the evidence that the petitioner has put forward to determine this matter without hearing from the respondent, it will be a miscarriage of justice?
No, can you ask the question again?
I'm asking that, are you saying from your arguments that if the Supreme Court goes ahead to determine this case, this petition that is before it, without hearing from the respondents, it will amount to miscarriage of justice?
Well, not necessarily, but justice demands that the truth be told. And that is why we are in pursuit of the truth.
All sides are ahead. Okay, let me do the tree.
Okay, thank you.
Okay, he wants to ask the last question.
Justice be done.
Justice
Well, are you know the outcome of our review application? No, you know the outcome of the review application. Are you predicting? Well, I mean, you see, you see, when it gets to a point in time that ordinary citizens, lay people, can predict court rulings, all right, I leave the justice or fairness of otherwise of the rulings to your judgment.
That's what the withdraw.
Very scotchy.
Okay. And your back court no, I see court no, akoye arehusem kakra. It's time say Jane Mensa oye electoral commission ni dream trainer abatra etu yi na gina ne so no ye ba nese enka court man ho kwan na nka o megina daka nu na nsem bebre amanfo bisa no watimi ya no ankoba ne sa court say oni ye nyadwen ntenanso biom akwakọ ye 70 a me no kase yi omo say wo mo ma ho kwan majemensa emma adaka nu na ne awo ho sem ne say ye mra ye adwuma organa ha no eye evidence act no section 72 ma ho kwan se obi a wo ne no kura nyadwen no kura wutumi fe no obeda no wadanse enne ye mra no mom adanchen ena yakofa ebruchie mra bibira be hihye mu a yedi aka asem enne ne hunya paso obi abehu ni se yen as petitioners no ya dwumpo ina ni se ye bedi nukura na chia kosisi ensa beka nukura no ensa ensa se ye pe nukura hunu a nukura ni ina ni se jemensa eba be gina de kanum na ne esi ya nkasa no waka ensa se wotwa nsem ni bia ka ya for example ye say ye di abanu bi keka ho vote pardon aya makmenua kasama na ekufadu wabeji atum say ayampa ye di abanu bi keka ho why na di abanu keka ho je mensa nkwa ne betime yi ano se wiye nu nsifi wa je mensa nkasa ba be ka kire ense waye mistakes bebre e wonu na asemu na denti na waye mistakes na anabe gina de kanum na kire ye from 30 a use form where di e ka sam na nkasa no why use form a what ye di use anya no nso na we use ye uko use form for enti ye na me no kase ye result baku enum a ye nim results kwa ye di edwuma Ghana enti se sana tie na nia ogina mu oye aba no ye se bra begina betuma na wo se unma why na betuma be kirekiре mu why na betuma be kire nsem na sie no we na sie why na betuma kire mu na wa kakra se Supreme Court baby Supreme Court dina no nanka I say Supreme Court can say me na say accountability ni yemfa evidence maye adi omo amaji atum say mistakes adia magbenu ankasa say the adia no bi keka ho enti adenti na o twanti for evidence bembi na baba kire say ye the adia no bi aka ho evidence be na kire say ye di ben ye mfa ne say go bi fufu bi kura na nya John Mahama no petition ya ankasa na baka so nkonko fa na results mra na ye results ye de ba court no eye nia o man no mra ama no ho kwan so on fa results mra ono ne jimensa wa bana se problem we wa ono kwa ni results na so baba kiretim onu ne yegina so se omra no nchire mu baako ayedai and mistakes yehu na yehu ye be say me chemo boss yen expectations ni de ye be die kire obi bisa say adenti na yen withdraw ne yen control da bi ya amasi ye be say wi ni kwa o ye ba nso say Ghana fo na be hu no kura wa asemi mu etan say John Mahama odo no wa ba for say obi be hu no kura wa asemi na wo utifi a utie mi no wo hu ni say abato na etu no kura enie e ba ni say mistake ba ha and a mistake amba ha abale sa na nie ye ba court no ne yasaka ye nsa ba ye ba court na no kura grab ya eno ani ade epe no kura enti ne yo ha ye da mo ase can go this way yeah.